Please be seated. Mr. Guy, you may proceed.
May it please the court, counsel. Good afternoon. The human heart, it has a great many functions, but is not the most important purpose what it causes us to do. It moves us, it motivates us, it inspires us, it leads us, and it guides us, our hearts, in big things like what we choose to do for a living, and in little things like what we do every day at any moment in the day. So if we really want to know what happened out there behind those homes on that dark, rainy night, should we not look into the heart of the grown man and the heart of that child? What will that tell us about what really happened out there? That's what was in George Zimmerman's heart. And the defense attorney can make fun of the way I say it, but it's not my voice that matters. It's yours. And we're about to hear from you. What does that say to you? Was he just casually referring to a perfect stranger by saying effing punks? That doesn't evidence to you anything? That's normal language? Or is that not what was in that defendant's heart when he approached Trayvon Martin? What does that tell you? It's funny. He put on a timeline that was 10 feet long, and the only thing he skipped was those two words at the bottom of the screen. It was the only thing. Think there was a reason for that? Think your reason he didn't want you to think about that again? How powerful that is? What that defendant was really feeling just moments before he pulled the trigger? Think that was a coincidence? What was in Trayvon Martin's heart? Was it not fear that Ms. Gentile told you about? The witness who didn't want to be here? The witness who didn't want to be involved? But the witness, the human being that was on the phone with the real victim in this case, Trayvon Martin, right up until the time of his death. Was that child not in fear when he was running from that defendant? Isn't that every child's worst nightmare? To be followed on the way home in the dark by a stranger? Isn't that every child's worst fear? That was Trayvon Martin's last emotion. There's a old saying, great one though. As a man speaks, so is he. The words on the screen were the last thing these people said before Trayvon Martin was murdered. Before this defendant had a motivation to lie, to justify his actions. What were his words? What was in his heart? If ever, there was a window into a man's soul, it was the words from that defendant's mouth on that phone call. And if ever there was a question about who initiated the contact between that grown man and that child, it was again those defendants' words. When he told Sean Nofke, just have the officer call me on my cell phone and I'll tell him where I am. George Zimmerman was not going back to the car or the clubhouse or the mailboxes. And if there was ever any doubt about what happened, really happened, was it not completely removed by what the defendant said afterwards? All of the lies he told, all of them. What does that tell you? There's only two people on this earth who know what really happened, and one of them can't testify, and the other one lied. Not about little things like his age or whether or not he went to the hospital, but about the things that really, truly matter. And not one lie, over and over and over again. What does that tell you about what really happened up there? Why did he have to lie if he had done nothing wrong? The bottom line, think about this. If that defendant had done only what he was supposed to do, see and call, none of us would be here. None of us. But that's not who he was. That's not where he was that night in his heart. After months of these people getting away. Not tonight. Not this one. Not that guy. That's why he got out of the car. If he really wanted the police to get Trayvon Martin, what would he have done? He would have stayed in his car and driven to the back gate where he had told them so many times they always go through the back gate, and he would have waited for the police. But that's not what he had in his heart. Trayvon Martin may not have the defendant's blood on his hands, but George Zimmerman will forever have Trayvon Martin's blood on his. Forever. Let me give you one more old saying. Maybe the most important one you're going to hear. And that is, to the living we owe respect, but to the dead we owe the truth. On behalf of the state of Florida, I submit to you that Trayvon Benjamin Martin is entitled to the truth. And it didn't come from that defendant's mouth. It didn't. He told so many lies. That's why we're here. By the end of the night, that is what was in Trayvon Martin's heart. The defense attorney said, what evidence is there that the defendant followed Trayvon Martin after he said okay? He challenged the state. Well, I've got an answer. What happened after 1913-43 when that defendant hung up with Sean Nockey? In 1915-44, when Rachel Gentile heard the thump and the end of Trayvon Martin's life. The defense attorney gave us a nice demonstration of what happens in 4 minutes. Well, what was that defendant doing for those 2 minutes? Watch the walkthrough again. Watch it. Because he tells you exactly where he hung up. He's walking back in the direction of the T, and he says, I got off the phone and I continued to my car. Maybe 10 seconds before he got to the T. It was 2 minutes. 2 minutes. He wasn't going. 4 minutes is not the amount of time do it in the jury room. If he was waist, and pop, or he had hit him, couldn't touch him. The defendant didn't shoot Trayvon Martin because he had to. He shot him because he wanted to. That's the bottom line. The common sense that tells you if Trayvon Martin had already run off like he claimed in his interviews, why would he go through the end of the T to get an address if he had already run off? Does that make any sense? Of course not. It's self-serving. It's justification. It's false. The yelling. Listen, please listen to that tape again. Jen Lauer's 911 call. Listen to when the screaming stops. At the instant of the gunshot. Silence. Nothing. If that defendant thought he missed Trayvon Martin, thought Trayvon Martin was still alive, so much so that he had to get on his back, flip him over, spread his arms out, why would he stop yelling for help? Why? If he was in fear. Does that make any sense? Of course not. If he was yelling that loud and that long, would he have sounded the way he sounded on the recordings that you have? He wouldn't have been hoarse. He wouldn't have had a strained voice if that was him yelling. Really? That's why common sense is so important. This isn't a complicated case. That tells you if he was the neighborhood watch coordinator, not anyone, the coordinator, who had lived there for 4 years, he'd know the name of Twin Trees Lane. The common sense that tells you if he was so afraid of the real suspicious guy with his hands in his waistband, he'd have never got out of the car. But that's not what happened. The common sense that tells you if he really was soft, didn't know how to fight, in his own words, he wouldn't have been able to get wrist control of Trayvon Martin. Those were his words. He wouldn't have been able to move his hand off his mouth or off his gun. If Trayvon Martin was putting on such a blow, that little plastic, flimsy kid's watch on his wrist, it wouldn't have come off. It didn't. The common sense that tells you, if Trayvon Martin was the one on the hunt, would he still have been on his cell phone? Would the earbuds still have been in his ears if he was getting ready to attack somebody? Really? And the most important one of all, the common sense that tells you in your everyday life, really, if he hadn't committed a crime, why did he lie so many times? Why did he lie? Let me remind you. Sean Nofke told me to get an address. That didn't happen. Listen to the tapes. Listen to the walkthrough and listen to the non-emergency call. Sean Nofke never said that. I told the police I was going to meet him at my car. That's not what he told them. Why? Why lie about that? It's so important, that's why. Because he wasn't going back to the car. He was going back to Trayvon Martin. Just like he said on that tape when he slipped up. Just like he lied about when he was confronted. It wasn't 10 seconds afterwards. It was 2 minutes. Trayvon Martin covered his mouth and nose. Really? They want you to believe that the blood was washed off by incompetent medical examiners. But yet he told the police, not just the police, his best friend, remember his best friend in the world, that Trayvon Martin was squeezing his nose. Do you really think if that were true, there wouldn't be George Zimmerman's blood on these sticks that they pried under his fingernails? Do you really think that's true? That was a lie. Concrete. You're kidding me. It's heavy. It's hard. If his head had been slammed into something like this, slammed, bashed over and over, he wouldn't look like he did in those photographs. Think about it. That would be it. Dozens of times, he said, dozens of times, punched in the face. That would be it. Was he injured? Yes. Was he injured seriously? Not close. Not close. I mean, they can call their expert and show him all the pictures of the lumps on his head. Were any of those serious? Didn't Trayvon Martin have a right to defend himself too? Remember Lindsay Fulgate? He didn't have so much as a headache the next morning. Not nausea, not vomiting, not a headache. And he didn't come to see me for treatment. He came for a note for work. It wasn't that bad. It wasn't bad at all. Would Trayvon Martin's hand look like that if he had been pummeling him? He said Trayvon Martin saw his gun. First of all, it was inside his waistband. Inside. Second of all, Trayvon Martin's legs were covering it. He couldn't have got to it. Trayvon Martin couldn't have seen it. Do you think for a second, seriously, do you think for a second that if Trayvon Martin had seen that gun ever, there'd be a gunshot at 90 degrees in the center of his chest? Do you think that? I mean, Mr. Stay Puft, Mr. Softy, was going to be able to get a shot directly through the center of his chest with Trayvon Martin knowing that gun was there, fighting for his life? Do you think that? Why was it so important to say he spread his arms out? Because he had to make Trayvon Martin menacing, violent, threatening. So I had to put his arms out. They weren't. They weren't. They were not. They were clutching the bullet wound on his chest. The car. He had to make him sound menacing to justify what he had done. Listen to those tapes again. There's the only two you have to listen to. The walkthrough and the non-emergency. Play them side by side right after each other. It's physically impossible, the way he told the police, impossible, that Trayvon Martin ran behind those homes, came back and circled his car. Why is he lying? He didn't want to know about Stand Your Ground. Didn't want the police to know he knew about it. Stand your ground? What's that? And let me suggest to you, in the end, this case is not about standing your ground. It's about staying in your car like he was taught to do, like he was supposed to do. And he can't now cloak himself with the noble cause of a neighborhood watch coordinator, violate its cornerstone principle, and expect you to absolve him of his guilt. He changed the story. This is where he told Detective Singleton he first saw Trayvon Martin. And this is where he showed him on the walkthrough. Watch the walkthrough again. Why did he lie about that? Why was it important that he came in through that cut like everybody else he had told the police? That he came through the cut because he had to make Trayvon worse. Had to make him worse, more menacing. That's why he lied. He told some people Trayvon Martin said one thing, and then it got worse. He told him he said something else. He reached for my gun. Had to make it worse. So he told Mark Osterman, his buddy, no, he grabbed my gun. He told him between the hammer and the back. Why? Why is he doing this? Told Mark Osterman, he circled his car at the clubhouse. He told the police, he circled it where he finally parked his car. He never circled his car. Told somebody he got his cell phone out. Told other people he was reaching for his cell phone. That's what he was taught. Don't be a vigilante. Don't. See and call. Don't get out. Don't follow. Don't pursue. Don't try to detain. Just call. Just call. And they gave him a little special book. as the coordinator, what not to do. What did he do? And think about this. The defense referred to George Zimmerman as a responsible gun owner in their opening remarks. A responsible gun owner. What did he do after the shot was fired? Did he yell for an ambulance? Call 911? Get an ambulance here? I had to shoot somebody? Did he roll Trayvon Martin onto his back so he could breathe? He just stood there and he watched and he waited while Trayvon Martin was face down. The bottom line is, who is responsible for Trayvon Martin lying on that ground? Trayvon Martin didn't kill himself. And who's responsible for the state not being able to ask Trayvon Martin to step forward so I could put my hand on his shoulder? God, I'd love to do that. Who's responsible for that? And Trayvon Martin is not, was not, will never be a piece of cardboard. To the living we owe respect, but to the dead we owe the truth. It probably seems like a year ago that we were all in here, one by one, and then as a group, in jury selection. And one question got a smile from everybody, but it's important. When the attorneys asked you, do you understand? It's not like TV. It was an important question, because it's not. And now you know, it's not like TV, where all the witnesses are well-dressed, well-educated actors and actresses. There are no Rachel Gentels on CSI. And they don't call people like Kristen Benson, who found nothing in a fingerprint from the gun on Law and Order. It's not like that in real life. In real life, we give you everything. The good, the bad, the indifferent. Because when that defendant is entitled to a trial, he's entitled to a fair one. All of it. All of it. And now you have that. In Hollywood, they write it up the way it happens on Sunset Boulevard. But in real life, it happens just like it did on Twin Trees Lane, in front of so many good, unsuspecting people. And remember, if you get back there and you don't like some of the witnesses in the case, you don't like Rachel Gentel or Shipping Bow, or the fact that there isn't this evidence, or the fact that there isn't that evidence, ask yourself, who produced this trial? Who made up the witness list? Who created the evidence? Who chose the circumstances? Who chose the lighting? Who chose the time? Who chose the weather conditions? It wasn't me. It was the defendant. He chose everything. And that's why we're here. And that's why the evidence is what it is. But it is enough with your common sense. It is enough. And I'm not asking you to fill gaps. I'm asking you to do what you do every day. Start from the beginning. Get to the end. And apply your common sense. And don't misunderstand me. Your verdict is not going to bring Trayvon Benjamin Martin back to life. Your verdict is not going to change the past, but it will forever define it. So what is that? What is that when a grown man, frustrated, angry, with hate in his heart, gets out of his car with a loaded gun and follows a child, a stranger, in the dark, and shoots him through his heart? What is that? Is that nothing? That's not anything? Is that where we are? That's nothing? Well, that's not his call, and that's not my call. That's your call. And I submit to you, the oath you took requires it. Trayvon Martin is entitled to it, and that defendant deserves it. Defense counsel went through this with you. I just want it real quickly because it is our burden, so indulge me, please.
A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death
Or great bodily harm. I mean, they can put this picture up, you know, they blew it up for you. It's bigger than life size, it's color. That's the fact. That's reality. That's what he looked like that night. When you wipe the blood away, that's what he looked like. Did that man need to kill somebody? Need to kill a teenager? They put up pictures of all the witnesses. They forgot that one. Defense attorney said in his, well, ask yourself, you know, if there's an issue about who lost the fight, ask yourself, who lost the fight? Who lost the fight? Who lost the fight? That's all evidence. Those are all facts.
In deciding whether George Zimmerman was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used.
He was, they estimated, 18 feet away from John Good. He knew the police were on their way. He knew that people were opening their windows and opening their doors. And when he shot him, he knew Trayvon Martin wasn't on top of him, so he could get his gun. Under those circumstances, under our circumstances, did he really need to shoot? Did he have to shoot Trayvon Martin? No, he didn't. He did not. Before I get to reasonable doubt, let me just go through a couple of things in the time I have remaining that the defense mentioned to you. I wrote down a quote. He said, "Innocent itself is no protection." Exactly. It wasn't for Trayvon Martin. He said he could have gone home. The guy could have gone home in the same sense. He says, I guess, it seems. Why didn't he go home? Use your common sense. Did he really want to take this guy home with him to the residence where the only person there was 12-year-old Chad Joseph? Did he really want to lead the defendant to that residence? Just like the defendant said, remember? On the phone call, the non-emergency call, I don't want to give out my phone number. Why? Dennis Root said there's no other option for the defendant. For everybody else there is. I mean, he had to admit that. He could have done other things, but he said for the defendant, there wasn't another option. But consider this. This is so important when you consider his opinion. The only evidence he had about what was happening at the time the shot was fired was from who? Self-serving statements from the defendant. That was his opinion based on that. And when I asked him, when I got on the floor, how could he get the gun with Trayvon Martin on top of him? The words were, somehow, somehow. Like I said, if y'all have to do it, get on each other. You won't get the gun. You won't until you get off. Why give so many statements? The defense attorney asked. If he was guilty, why would he give any statements? Why give so many? Because he had to justify his actions, and that's why it kept getting worse. That's why by the time he got to Mark Osterman, it was completely different. That's why it kept increasing. That's why when he got to Sean Hannity, wow. It was God's plan. By the time he got to Sean Hannity, it was God's plan. The defense attorney mocked me. That's fine. Because I said he pushed the gun into his chest. He didn't. He didn't. It was a contact wound with his shirt. He didn't push the gun into his chest. A reasonable doubt is not a possible doubt, and a speculative doubt, an imaginary doubt, or a forced doubt. And it's kind of funny the way they do the instructions. They don't tell you what a reasonable doubt is. They tell you what it's not. But let me suggest to you, a reasonable doubt is something you can attach a reason to. Use this definition as guardrails for your deliberations. If you get back there and one of you says, well, maybe this happened, or couldn't this have happened? Or isn't it possible this? That's not a reasonable doubt. A reasonable doubt needs to be two things. It needs to be reasonable, common sense, reasonable. And it needs to go to an element of the crime. If you have a question about something that doesn't go to an element of the crime, and Judge Nelson's about to spell those out for you, probably after the lunch break. If it doesn't go to one of those elements, it's not a reasonable doubt. A reasonable...
Sorry, I apologize. I need to interrupt and approach the bench maybe for a moment.
Okay.
Or I can state it now.
No, approach the bench. Ladies and gentlemen, again, after the Final arguments have been concluded. I will instruct you on the law that's applicable to this case. You will be taking that law back to the courtroom with you. Thank you. You may proceed.
Thank you, Judge.
Listen to the court when you get the law.
This is what she'll tell you. A non-reasonable doubt.
Something that's not reasonable, possibility, imaginary doubt, or forced doubt, must not influence you to return a verdict of not guilty. Let me just address one more thing with you before I close. And that was, it was brought up actually by the defense. It was brought up by the defense in their summation this morning, and it was brought up by the defense in the trial. Not by the state, but by the defense. Race. This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race. To the living, we owe respect, but to the dead, we owe the truth. What do we owe Trayvon Martin? 16 years and 21 days, forever. He was a son, he was a brother, he was a friend, and the last thing he did on this earth was try to get home. This is the dead. The self-serving statements, the lies from his own mouth, and the hate in his heart. Words that they can't now take back. The physical evidence which refutes his lies. And the law that Her Honor is about to read to you, the law that applies to all of us, and the law that applies to each of us. This is the truth. Thank you for your time.
Ladies and gentlemen, I'm going to read the jury instructions, but I want to give you a choice. Would you like to have these instructions read after lunch, or would you like to have them read now and then go to lunch? After lunch? Okay, I will respect that. Please put your notepads down before you go to lunch. I want to admonish you again. You are not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? Okay, thank you. We'll be in recess until 2 o'clock. If you'll all work on the exhibits that are go back and it's agreeable it's all in order?
Care of it.
Okay, perfect. All right, let's bring the jury in. For those of you seated here, during my reading of the jury instructions, nobody will be allowed to come in or come out. If you don't want to sit throughout the jury instructions, the time to leave would be now. Nobody's jumping up.
Jurors present, Your Honor.
Please be seated. Ladies and gentlemen, while you're getting settled in, I'm going to ask you my questions. If your answer is yes, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about this case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, tweets, blogs, or social networking pages about the case? Thank you very much. This time, ladies and gentlemen of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give you. The packet from which I'm reading will go back into the jury room with you, so you don't need to take notes. George Zimmerman, the defendant in this case, has been accused of the crime of second-degree murder. In this case, George Zimmerman is accused of second-degree murder, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Trayvon Martin was killed by George Zimmerman, you will then need to consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the attempted killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before George Zimmerman may be found guilty of second-degree murder or any lesser crime. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Trayvon Martin is dead. 2, the death was caused by the criminal act of George Zimmerman. 3, there was an unlawful killing of Trayvon Martin by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove George Zimmerman had an intent to cause death. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of Trayvon Martin, you should find George Zimmerman guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find George Zimmerman guilty of second-degree murder with discharge of a firearm. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find George Zimmerman guilty of second-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that George Zimmerman carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that George Zimmerman committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if George Zimmerman is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. The killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the attempted killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Trayvon Martin is dead. 2, George Zimmerman intentionally committed an act or acts that caused the death of Trayvon Martin. George Zimmerman cannot be guilty of manslaughter or committing a merely negligent act, or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the killing. The killing of a human being is excusable and therefore lawful and under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that George Zimmerman had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. If you find George Zimmerman committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the manslaughter, George Zimmerman carried, displayed, used, threatened to use, or attempted to use a firearm, you should check the appropriate box on the verdict form, which I will discuss with you later in these instructions. The definition of firearm has previously been provided in these instructions. An issue in this case is whether George Zimmerman acted in self-defense. It is a defense to the crime of second-degree murder and the lesser included offense of manslaughter if the death of Trayvon Martin resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. In deciding whether George Zimmerman was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing George Zimmerman need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, George Zimmerman must have actually believed that the danger was real. If George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of George Zimmerman and Trayvon Martin. In your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether George Zimmerman was justified in the use of deadly force. You should find George Zimmerman not guilty. If, however, from the evidence you are convinced beyond a reasonable doubt that George Zimmerman was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. George Zimmerman has entered a plea of not guilty. This means you must presume or believe George Zimmerman is innocent. The presumption stays with George Zimmerman as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome George Zimmerman's presumption of innocence, the state has the burden of proving the crime with which George Zimmerman is charged was committed, and George Zimmerman is the person who committed the crime. George Zimmerman is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt should not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find George Zimmerman not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of George Zimmerman may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find George Zimmerman not guilty. If you have no reasonable doubt, you should find George Zimmerman guilty. The state must prove that the crime was committed on February 26, 2012. It must be proved only to a reasonable certainty that the alleged crime was committed in Seminole County. It is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The Constitution requires the state to prove its accusations against George Zimmerman. It is not necessary for George Zimmerman to disprove anything, nor is George Zimmerman required to prove his innocence. It is up to the state to prove George Zimmerman's guilt by evidence. George Zimmerman exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that George Zimmerman did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by George Zimmerman outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that George Zimmerman's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when George Zimmerman made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude George Zimmerman's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Excuse me. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if George Zimmerman has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if George Zimmerman is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. During this trial, I have permitted you to take notes. You will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid in your individual memory. You should not compare your notes with those of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find George Zimmerman guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It is as follows. It reads at the top: in the Circuit Court of the 18th Judicial Circuit in and for Seminole County, Florida, case number 2012 CF 1083A, State of Florida versus George Zimmerman. Verdict. Under the word verdict, there are 3 lines. Next to the first line, it reads, "We, the jury, find George Zimmerman guilty of murder in the second degree as charged in the information." Next to the second line, it reads, "We, the jury, find George Zimmerman guilty of manslaughter, a lesser included offense." Next to the third line, it reads, "We, the jury, find George Zimmerman not guilty." You're to place an X on the line that reflects your verdict. Under that, it says special findings. If you find George Zimmerman guilty of murder in the second degree, you must choose one of the following. There are 4 lines. Next to the first line, it reads, "We find that George Zimmerman discharged a firearm causing death or great bodily harm to another during the commission of this offense." Next to the second line, it reads, "We find that George Zimmerman discharged a firearm without causing death or great bodily harm to another during the commission of the offense." Next to the third line, it reads, "We find that George Zimmerman actually possessed but did not discharge a firearm during the commission of the offense." Next to the fourth line, it reads, "We find that George Zimmerman did not actually possess or discharge a firearm during the commission of the offense." If you find George Zimmerman guilty of manslaughter, you must choose one of the following. There are 2 lines. Next to the first line, it reads, "We find that George Zimmerman carried, displayed, used, threatened to use, or attempted to use a firearm during the commission of the offense." Next to the second line, it reads, "We find that George Zimmerman did not carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense." You're to put an X by the appropriate line if you so find. So say we all, a line for the foreperson to sign and to date. In just a few moments, you will be taken to the jury room by the court deputy. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Your verdict finding George Zimmerman either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. At this time, if all of you will please take your notes with you and follow Deputy Jarvis back into the jury. Yes, just 1 minute. Yes, you may. Is there any, just so everybody knows, the alternates E54, E13, and E28 have been separated, have not gone back with the jurors, and they will be discharged given their proof that they've been here on this jury all the time to bring back to their employers. Is there anything else we need to take up before we recess? Okay, counsel, if you'll please leave your phone numbers with the clerk. All the evidence is there. Bobby Ray, you need to take these instructions, a verdict form. About the gun, I don't want to send the bullets back. Any objection to sending the gun after it's been once more cleared by the court deputy and the lock been put back on it?
No objection, Your Honor, and no objection to leaving the ammunition inside.
The ammunition will not go back. Okay? All right. Thank you very much. Court is in recess.